afternoon, everyone. Let's get started. I know Commerce Committee's running a little late, which means we're missing a member, and I think we're actually missing a conferee as well, but we'll work through this and hopefully they'll get up here shortly. So we have 2 bill hearings today and then some bills that I would like for us to get worked. We'll get started with that first bill hearing. It's House Bill 2389. We'll open that hearing and have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2389 authorizes a notice to appear for unlawful possession of marijuana and defines complaint in the Kansas Criminal Procedure Code to include that notice to appear. So the bill amends KSA 222202. That's the definition section for the Code of Criminal Procedure. It amends the definition of a complaint to provide that a notice to appear issued by a law enforcement officer pursuant to KSA 222408 for a violation of possession of a controlled substance when the substance is marijuana meets the definition of a complaint for use throughout the code. Under current law in KSA 222408, a law enforcement officer may issue a written notice to appear for any act punishable as a misdemeanor and release the person detained for such act. And so by amending the definition of a complaint, that notice to appear will satisfy the law enforcement officer's obligation under KSA 222408, paragraph 5, to file a complaint in the court in which a person released is given a notice to appear, charging the crime stated in that notice to appear. And I can take any questions.
Do you have any questions for Natalie? Do not see any. We will move on to proponents. Representative Croft is a proponent. He's still in Commerce, so we're gonna we'll do former Senator Greg Smith.
Mr. Chairman, can you hear me? I've been having microphone problems today.
We can, and I think you're a little quiet, but I think we can adjust for that on our end.
Okay, I apologize. Quite simply, Mr. Chairman, this is an issue we've been working on for decades, and it's a matter of equity. Depending on the uniform that an officer wears, depends on whether or not you go to jail for a simple possession charge. City officers are able to write an MTA, a citation, and release people at the scene because of the complaint issue that Natalie described. We are not. We're required to book a person in, fingerprint, process, and do the whole 9 yards. And this would just make it a fair process for everybody. With that, I'll stand for questions.
Any questions, anyone? I don't see any. We will skip over Representative Croft, and we're going to move on to neutral. You ready, Mr. Seal?
There
we go.
Okay, all right. Thank you, Chairman Pat, members of the committee. Kendall Seal, Director of Advocacy for the ACLU of Kansas. We're neutral on House Bill 2389. We support decreasing penalties for the possession of marijuana. Although this won't reduce the criminal penalties for marijuana possession, this bill will reduce the collateral consequences. We're supportive of that. We would hope that the committee would consider broadening the category beyond marijuana. And that's also why we're neutral. We would lift up data on the issue of significant racial inequities present in the current system, specifically the fact that Kansas racial disparities in drug arrests is higher than the national average, ranking 12th worst in the country for largest disparities in marijuana arrests. We urge this committee to amend House Bill 2389 to broaden the reach to more Kansans. Fundamentally, we believe it's a public health issue and not a criminal justice one. Thank you.
Any questions, committee? Don't see any. We do have written proponent testimony from Ed Klump and Dennis Rock. Anyone else here as a proponent? Anyone here as a neutral? Anyone as an opponent? Okay, so I am going to leave this hearing open until Representative Croft shows up, but we'll go ahead and move on and open the hearing on House Bill 2376, and we'll make him wait until we're done with this one. So, Natalie, would you like to tell us about 2367?
Sure. Thank you, Mr. Chairman. House Bill 2376 requires law enforcement agencies to adopt a policy relating to making arrests for a violation of a protective order and procedures for separating suspects from the scene of it for a period of time. The bill amends KSA 22-2307. That's a statute that requires law enforcement agencies to adopt written policies related to domestic violence calls. This bill would add that those policies would be required to include a statement directing that when a law enforcement officer determines there is probable cause to believe that a violation of a protection from abuse order or a protection from stalking order has occurred, then that officer would arrest the person that the officer has probable cause to believe committed the violation. These policies would also be required to include provisions related to keeping the suspect away from the scene for a period of time if the officer determines such action is necessary to maintain the safety of all persons involved. And I can take any questions.
We have questions for Natalie? I'm not seeing any. We will begin with proponents, and we have Representative Neely.
Thank you, Mr. Chairman. First off, I'd like to propose an amendment removing the wording from line or page 2, line 8, from the comma to the end of line 10. That would be including procedures to keep the suspect away from the scene for a period of time if the officer determines such action is necessary to maintain the safety of all persons involved. The reason for amending that is that it becomes immaterial and everything with the rest of the bill should it be a mandatory arrest that will already be being done.
Okay, so if you want to, knowing that you intend to amend the bill, if you just want to continue when we work the bill, we can have Natalie prepare that, but you want to continue on explaining why you think this bill is a good idea.
Yes, after receiving some opponent testimony, I spoke with 3 officers and 1 sheriff's officer in 3 different counties, and much to their bewilderment, this is already being done. So basically it's wording. This already fits into the domestic violence statutes, and I think maybe Natalie, I should have asked this ahead of time, whether or not the domestic violence statutes on mandatory arrest make any distinction between a misdemeanor and a felony arrest. And I don't know if she can answer that.
Mr. Chairman, I believe what Representative Neely is referencing is the fact that this statute, KSA 22-2307, if you look at subsection B, print 1, starting there on page 1 at line 15, requires law enforcement agencies to adopt a policy related to those domestic violence calls, that if a law enforcement officer shows up to one of those calls and determines that there's probable cause to believe that a crime or offense involving domestic violence has occurred, then they shall, without undue delay, arrest that person. And so while some violations of a protective order as defined in the section that we're citing here, KSA 2159-24A1 or A6, some of those would fall probably in the definition of a domestic violence call. Some of those would be misdemeanors, some of them would be felonies. Some of those domestic violence calls would be misdemeanors and some would be felonies. So we don't really specify whether it just applies to misdemeanor or felony offenses here.
Very good. Anything else, Representative Neely?
No, I'll hold off for
Okay.
questions. Maybe.
Anyone else online or in person as a proponent? If not, we'll move on to neutral conferees, and we have Sarah Russ Martin with us online.
Thank you, Chairman Patton, members of the committee. First, I just want to say, well, I'm Sarah Russ Martin. I represent the 26 sexual and domestic violence programs serving victims across Kansas. And on their behalf and the coalition's behalf, we are neutral on this bill. recognizing that this bill is intended, clearly intended to help victims in dangerous situations. But we, in looking at existing law, just had some concerns with whether or not this would cause potentially some confusion around what is already in the statute. And we wonder if maybe sometimes the problem is more implementation than the actual law. So we have concerns around only A1 and A6 being included, because that does not include tribal orders or orders from out of state. With full faith and credit, they should be enforced across the nation and in Kansas. So we have concerns about those not being included. We have some concerns about whether or not a violation of a protective order, if committed in the context of domestic violence, isn't already a mandatory arrest, a shall language arrest issue. We always support clarifying that the protected party should not be arrested. We have a 10th Circuit Court of Appeals case that specifies that, but sometimes that is still an issue. So we are definitely always open to including that language in the statute. We are concerned that it is silent on 2310, which is a stalking response for law enforcement. What we are talking about here is 2307, which is a law enforcement response policy for DV, and not 2310, which is the response policy for stalking. And so because it's silent on that, it seems like it needs to be included there as well, if it's going to be included at all. And then the new language around procedures to keep the suspect away from the scene. We believe it needs to be very clear that that's if probable cause does not exist, because otherwise that can be interpreted that we're back before mandatory arrest ever occurred, where we're just separating parties and hoping for the best. And then lastly, we just think that sort of separation policy, we should just make that really clear in our opinion, so that we're very clear that this is only if there is not. It's not probable cause. And again, I just want to say it's clearly intended to help victims. We do not want to undermine that intent, but there seem to be some significant concerns with how this would fit within existing law. We're willing to work with anyone who is willing or interested, but those concerns remain. So I'm happy to stand for any questions. Thank you, Chairman.
Okay, Representative Carmichael.
Thank you, Mr. Chairman. Ms. Martin, I share your concerns, and I also share what I think is the intent of the proponents of this bill. I think it's worthy and so on, but I also share what I think are the serious concerns of Mr. Klump and his organizations as well. So given the entire circumstance, what would you prefer at this point? This bill or no bill?
That's Mr. Chairman, may I respond? Is that appropriate?
Go for it. Why not?
Okay. You're so kind.
Unless that was a reason for me to say no.
I give you my opinion, but I'm not the conferee.
Well, at this time, in reading the existing law, it really seems as though what we're intending to do with this bill is already captured in an existing statute. And that the problem is, clearly there was a problem, and it got brought to the attention of a legislator that it did not go well. And that is unfortunate, and that needs to be corrected, and folks need to be held accountable. But it seems as though that is an implementation issue more than a statutory construction issue. And so if I was to have to choose between what it is now and no bill, I would probably choose nothing, because again, I think that what is trying to be accomplished here is written in. It's just clearly didn't get implemented the way it was intended to be.
Well, Ms. Russ Martin, as the committee knows, I never expressed my opinions during the questioning of conferees, so I won't say that I agree. Thank you, Mr. Chairman.
Any other questions? Seeing none, anyone else as a neutral conferee? Okay, we'll move on to opponents. And while I don't usually interject either, I will just say for the sake of those getting up to speak as opponents, I certainly think this is something that's an issue, something we need to work on, but we may not be there yet. And we only have till Thursday or Friday to pass bills. So I'm not sure this is something that can be fixed by then. So if you're an opponent, certainly let us know what you don't like about it. But I would encourage you all to work with Representative Neely and Sarah to try to come up with something if something's necessary. But we're probably not in a huge rush for that because I doubt that can be pulled off in the next couple days. So now that we're at opponents, Ed Klump, you're up first.
I think we're on. There we go. Ed Klump. I'm here representing the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. We are opponents to the bill. I will point out that we do take violations of protection orders and stalking orders and all of those kind of orders very seriously. We do make arrests when it's appropriate to affect those. And we understand the safety of the victim, and we work very hard to do that. I'm going to skip over the part about the provisions that's going to be withdrawn. If you want some ammunition on why you should make that amendment if this bill moves forward, we'll read my testimony. And I'll be glad to answer any questions if people have them on that. So let's jump down to the bottom of the first page of our testimony. Let's talk about the proposal in section 1, subsection B1, page 1, line 18 and 19. And first of all, I think it's important to understand that a violation of a protection order is not always a felony. There are misdemeanor violations of protection orders. And we have KSA 215924, which directs when we can make an arrest on a misdemeanor. One is if we see it occur. We can make an on-view arrest. So if the person's still there in violation of the protection order, we can make the arrest. But beyond on view, then there are conditions that have to be met. And those conditions are on the top of the second page of my testimony, those A, B's, and C's there. The person will not be apprehended or evidence of the crime will be irretrievably lost unless the person is immediately arrested. The person may cause injury to self or others or damage to property unless immediately arrested, or the person has intentionally inflicted bodily harm to another. So not in all cases of a misdemeanor violation would we have the legal authority to arrest on, take the person into custody on a misdemeanor. And I don't think we can create a policy to override that state statute. So that's the first issue. There are exceptions when we make arrests, even on felony cases, and they're rare. But take, for example, if a person who is subjected or violating the protection order is seriously injured, we may opt not to arrest that person at that time and long form it and send it to the prosecutor and let them file a long form on it. There's several reasons for doing that. I want to point you to my footnote on the bottom of that page. There's a Kansas Court of Appeals case that was decided, I think it was last June. And what they said in that case, this was a case where Ottawa Police Department had been engaged in a pursuit of a vehicle. They lost the vehicle, lost sight of it, couldn't find it. They went on their way. The county found it, rolled and laying off in the weeds at the end of a entrance ramp that they exited off a divided highway on. Person was pretty seriously injured. They took him to the hospital. They didn't arrest him. He was drunk. And I don't remember if it was a felony DUI case or a felony attempt to elude case because of the DUI, but in any event, it was a felony. And what the Court of Appeals ruled is that there is a provision in state law, and I cited here in my testimony someplace, 8-2104D, which states that that person must be taken immediately before a magistrate if they commit a traffic felony. Well, the court ruled that that is a mandatory arrest provision. And since it is a mandatory arrest provision, the city and the county were responsible for the medical bills of that person because we should have arrested him under the law. And if we should have arrested him and would have arrested him, we would have been responsible for the bills. So there we have serious injuries we had nothing to do with. It was all on him, and yet we were being held responsible for those costs. That causes us a lot of concern. My first thought on that when I saw that case was, what about domestic violence cases? Because many, many times the perpetrator on a domestic violence case is also injured, sometimes in self-defense, oftentimes in self-defense. Are we going to be responsible now for all of those since we have a mandatory arrest law? And that's our objection on this one. We're adding another place that mandates we make an arrest without exception. And that's the problem. There is no exception to this. This would say you have to in every single case. And that's where we run into problems. We need some flexibility in making those decisions so that we avoid situations like this. And so I do understand that that case has been appealed to the Supreme Court. Hopefully they'll overturn it, but we'll be back next year if they don't, asking for some relief from this, because this could be very, very expensive for us. And I think that covers the main points that I wanted to make, Mr. Chairman, and I'll stand for questions.
Any questions, committee? Representative Neely.
Mr. Klemp, it says in the three reasons that you would make an arrest, B would be the person may cause injury to themselves or others, damage to property unless immediately arrested. Has that not already been substantiated by the fact that there's a protection order on this person?
I don't think in every case that would rise to the level of probable cause that they are going to immediately cause harm or damage just because they come to the person's property or they come to the place of business where the person that got the order works and makes no threats, no overt, acts to cause harm or anything. I think that would have to be decided on a case-by-case basis of the exact circumstances and what has been said by the person violating the protection order. I just don't think in 100% of the cases that would be there. I think in many of them it might.
I have one more question. In your written testimony, it says the frequency to injury to a person arrested for domestic violence is higher. It goes on to say those costs will be significant, ranging from minor treatment to emergency room before incarcerating the person in jail, to various serious injuries such as gunshot wounds, stabbings, treating severe drug overdoses, severe intoxication, medical problem, domestic violence incident, or heart attack or stroke. Couldn't any of these happen in any arrest that's made and everything by a law enforcement officer?
They can, but when you make it a mandatory arrest, we don't have the option of going a different route and deferring to the prosecutor whether or not they're going to file a charge. Keep in mind in many, many domestic violence cases where we make a mandatory arrest, formal charges are never filed because of various reasons that the prosecutor doesn't feel that they have enough to get to proof beyond a reasonable doubt. And so when we have a mandatory arrest, then we're going to assume many more of these cases and costs where there are injuries or an illness or an overdose, because it doesn't matter what that medical need is or how it was created. Once we take that person into custody under the U.S. Supreme Court laws or case laws, we are responsible for their medical care and costs without exception.
Any other questions? Representative Carmichael.
Thank you, Mr. Chairman, and thank you, Mr. Klemp. I appreciate your testimony and position of Kansas law enforcement. Just so that we are clear, in those circumstances where a potential defendant or a person subject to arrest does suffer serious injuries, which may be expensive to treat and care for, I think as a practical matter, what happens is that law enforcement, of course, calls EMS so that these folks receive whatever treatment they need. They're transported to the hospital. They're presumably taken care of there, oftentimes on the public dime, because we don't have Medicaid expansion. But once they are released from the hospital, then they may be greeted by an officer who holds in his or her hand an arrest warrant, and then they go to jail. Is that the way that works?
Well, there are occasions where law enforcement has been known to try that. However, there is a statute that covers, states that law enforcement cannot release a person from an arrest for the purpose of avoiding the medical costs. And so courts have ruled against us in some of those civil cases filed by the medical facilities, and said that, you know, we did that by demonstrating that we wanted to be notified when they were ready for release, and then we go arrest them.
And I do appreciate that, and I'm actually semi-familiar with that line of cases. But to try to rehabilitate my question, I think the concept is that you don't want a mandatory arrest law, because then the city or county are going to be liable for the medical bills under at least the Court of Appeals decision, whether you make the arrest or not, because the law says thou shalt arrest. And then you do make the good distinction that technically you can't have the hospital call so that you can arrest them right there, but once they're out of the hospital, presumably law enforcement finds the folks, executes the arrest warrant, and then they're on their way to the system without the city or county being responsible for the medical bills. Would that be a better way for me to have phrased my question?
Well, that's a little bit different twist on the question. Yes, I think we might still be in trouble with that, because by making that that probable cause arrest shortly after the person's released from the hospital, I could see the courts saying, well, that's the same thing. You know, you didn't arrest him, so why did you not arrest him in the first place? Well, because I wanted to send it to the district attorney and let them file the long form. But then when you go back and you make a probable cause arrest, in spite of that, we've pretty much demonstrated that my intent was just wait till they got out of the hospital.
Well, I thought you and I were going to be able to agree today, Ed, but it looks like we're not. But I don't want to prolong this discussion today. We can have it at a later time, because I disagree with that interpretation of the law. Thank you, Mr. Chair.
Any additional questions? Don't see any. Thank you, Ed.
Thank you, Mr. Chairman.
Next, Greg Smith's with us on this bill too, online.
Thank you, Mr. Chairman, and given your statements, we'll just go ahead and stand on written testimony and
Very good, thank you. Any questions? Seeing none, we have Amanda Stanley, who is a written opponent. Correct, Amanda? Yes, okay. Anyone else as an opponent? Not seeing any, so we will close the hearing on House Bill 2376. We will go back to House Bill 2389 and welcome Representative Croft to the committee.
Thanks, Mr. Chair. Mr. Chair, committee, my apologies for being late. I was, anyways, I was detained on the way in, telling me I have to appear tomorrow for something else. This bill, as brought forward, was brought to me by the county sheriff of Johnson County with a concern about some consistency between local, state, and county law enforcement, where they have to do something different, even though it's the same offense, but they have to do things differently, which causes some concern or confusion with those that are with the population. And no point in trying to undercut with something that's done in statute, or at least where we're requiring them to do something different. So this bill was simply about trying to add consistency between all three of those levels. This is not addressing the other issues, and I know that the neutral conferee does talk about that. I agree. That's not what this bill's about. This is just about adding consistency. So with that, Mr. Chair, thank you. I'll stand for questions.
Committee, this is your chance. Any questions for Representative Croft? Representative Jennings.
Thank you, Representative. Glad you could be here. Your preamble to your conversation here was that you were stopped along the way and had to appear someplace tomorrow. I wonder if that engagement has anything to do with subpoenas or summonses, or was it, whatever you feel like you can share.
Well, there actually is a bill that I was working on with subpoenas, but that is not the issue for tomorrow. Although it might be if I don't show up with the Senate Commerce Committee tomorrow, so.
Okay, not seeing any other committee
He
questions.
might want to confer with Representative Owens before tomorrow.
Thank you for joining us.
Thank you, Mr. Chair.
Committee, I will now close the hearing on House Bill 2389. Thank you all. We will now work through some bills. We'll start with 2390. And as soon as Natalie pulls that one up, we will have her refresh our memories.
Thank you, Mr. Chairman. House Bill 2390 is your annual review of the exceptions in the Kansas Open Records Act. So it makes permanent those exceptions to disclosure that would otherwise expire July 1 of this year.
Any questions for Natalie? Is there Representative Jennings, you have your hand up.
No amendment, but I would make a motion that the committee recommend favorably, and since it's non-controversial in nature, that it be placed upon the consent calendar.
We have a motion by Representative Jennings, a second by Representative Wheeler. Any discussion on moving this forward on the consent agenda? Representative Carmichael.
Thank you, Mr. Chairman. I generally think that's a good idea, but I want the committee to be aware that a couple of years ago, one of my members amended a similar bill as it related to disclosure of certain records at the Secretary of State's office. And while I don't know that, and by the way, that amendment was successful and became law, I don't know whether such an amendment lies somewhere in this building, but if it does, we might be better off to just go ahead and run it across the floor. I think the speaker realizes it's must-pass legislation. And if we put it on consent and then a member has to object so that they can try to run an amendment later on the floor, I'm not sure it makes the process any quicker, but that's just my thought. Thank you.
Representative Wheeler.
Thank you, Mr. Speaker. Just a quick question back to Representative Carmichael, because I don't particularly recall that amendment. Was that back when Secretary of State was last name Kobach?
Mr. Chairman, may I respond?
You may.
As a matter of fact, it was, and it was an amendment dealing with disclosure of provisional voting lists.
Thank you, sir.
I'm sticking with it. There's plenty of time. We've got most, if not all, of next week on general orders, and if somebody wants to pull it off, they can pull it off, but I think it'd be more expeditious just to move it forward. This is pretty perfunctory action.
Okay. Any other discussion? Representative Jennings, you may close.
Mr. Chairman, I close.
Heard the motion. All in favor say aye. All opposed say no. The affirmative votes wanting recorded: Owens, Jennings, Hoheisel, Heiberger, Neely, O'Hobson, Carmichael. I get everybody? I don't believe there were any no votes. Okay, let's move on to 2154. Natalie, sorry. Just assume you know. I'm going to call on you next.
Yes, thank you, Mr. Chairman. House Bill 2154 authorizes the Department of Education to contract with private vendors to install and operate school bus cameras on the school buses. And I can take any questions.
You have any questions for Natalie? Are there any amendments? What's the pleasure of the committee? Representative Hoheisel?
Thank you, Mr. Chair. I move that we pass out 2154 favorably.
Seconded by Representative Owens. Any discussion? Representative Carmichael.
Thank you, Mr. Chairman. This bill is a vast improvement from what we have seen over the past several years. And I don't want to unduly try to torpedo the bill because I know the intent is good. I'm not going to vote for the bill because, number one, and probably most importantly, outsourcing of law enforcement responsibilities to private for-profit entities is a slippery slope. I don't think it is a good idea. I think it leads to collateral consequences that do not justify the good intent of the bill. I also believe that there are practical considerations here. We heard the gentleman who sells these cameras explain to us that he is prepared to put these cameras on every school bus in Kansas at a cost of $10,000 per school bus. I don't know how many school buses there are in the state of Kansas. I should have asked, but I seriously doubt that this gentleman and his company have the credit line that would be necessary to do that. And so we may be creating a bill which only works in the places where there is a relatively high density of population, where there is easy and available access to the internet. I think that the real concerns that we have heard expressed repeatedly are that out in the country, the police can't be everywhere. I'm not sure that this bill is going to take care of that problem. I also do not like the fact that, as a practical matter, once this bill took effect as law, I think we'll see very little effort on the part of law enforcement to enforce the criminal statutes or the traffic statutes. And that means that we are effectively, substantially lessening the penalty for this crime. We're making it $250 instead of nigh on $1,000 for a third violation. We are taking away the points, if you will, that go toward people's driver's licenses and their insurance. And so far as I know, I haven't driven past a school bus stop arm that I can ever remember. But if that was my modus operandi, I would much rather be subject to a $250 civil penalty than up to a $1,000 fine, potentially loss of my driver's license because by then I'm on my third offense, increase in my insurance rates. I know that Kansas law enforcement has a lot of things to do, and we keep putting more burdens on them every day. But this is a serious crime, and if law enforcement has time to set up a speed trap 2 blocks from my house and run it before school and after school on a regular basis where they apprehend high school students for speeding, I think they have time to do selective enforcement to save children's lives. So I'm not going to support this bill, but I will grant you it is far better than what we have seen in the past. Thank you.
Discussion? Representative Owens?
Thank you, Mr. Chairman. I thought I would just take an opportunity to share my thoughts as it relates to this bill. Sorry, I'm hearing some echo on my own. First of all, you know, law enforcement can't be everywhere. And we know, based on the data that has been proven about how effective this is in other states, that this bill could literally save lives. It does provide a law enforcement oversight aspect to ensure that a law was actually broken before the bill gets sent out. I mean, honestly, I'm sure that if there is a concern that the penalty is not stiff enough, I'm quite certain that the owner of the company would be more than happy to raise the fine to $500 or $1,000, whatever this committee wishes. But I think that this is a good start in replacing what the fact that, as mentioned, law enforcement can't be everywhere. One other thing that I might mention as it relates to the funding, I can assure you if this company receives a state contract like this, there could be 300,000 buses and he wouldn't have a problem funding it. And that's how venture capital works. That's how raising capital works. So I wouldn't have any concern with that whatsoever. So thank you, Mr. Chairman. I look forward to supporting this bill.
Any further discussion? Do not see any. Representative Hoheisel, you may close.
I close.
Heard the motion. All in favor say aye. All opposed say no.
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 Motion carries. The affirmative votes wanting to be recorded: Owens, Hoheisel, Heiberger, Neely. The no votes wanting to be recorded are Ohabisam and Carmichael. We'll now move on to 2227. Natalie.
Thank you, Mr. Chairman. House Bill 2227 allows the Chief Justice to suspend certain time limitations during a state of local disaster emergency, allows the suspension of verification requirements for appeals, allows the use of electronic audiovisual communication to expeditiously resolve cases, and extends the Chief Justice's authority to suspend time limitations until June 1st of 2022.
Any questions for Natalie? Okay, I have one amendment. Natalie, this is the pause button amendment. So as this one's getting distributed, this came from the court after our hearing, and they had a little bit more thought or time to think about it. What this does is it adds some language to clarify what happens when the chief's order goes away. So the time's up, the disaster's over, and the chief takes her order away, and deadlines are no longer suspended. What happens then? So if you're in a case and there were still, you had 10 days to file some motion, basically what this says is when she releases that button, you still have 10 days. And then the other situation is if the deadline never began to run because the order was in effect when your time would have begun, then you get the full amount of time. So as soon as you get this, you can read through it. It outlines those two scenarios: what happens for cases that were paused midstream, and what happens for ones that have not yet been started. And anything I've left out, Natalie, that you want to add?
No, Mr. Chairman. I think you described it well.
I will make that motion, seconded by Representative Hoheisel. Are there any questions on the amendment? Oh, okay, apparently it's just popping up, so I'll give you a second. Representative Ralph.
Thank you, Mr. Chair. A question that comes to mind, and I apologize for not having read back through the bill probably sufficiently, but in reading the amendment, it talks about having the same amount of time as you had before the order was implemented. And I recall occasions where if you're about to run out of a time frame and you filed some type of a claim with the state or with a municipality, and then coming out on the other side of it, having at least a minimum amount of time. So, for example, if somebody had a day left on their time frame when this order was put into place, and then when the order comes off, if they're still left with just that day, there seemed to be some concerns at that point of the person being able to actually respond in a sufficient amount of time, unless you put a minimum amount of time coming out on the other end of it. The same amount of time, but never less than 10 days or 15 days. Would there be any concern about that in this circumstance of coming out on the other end of these orders and someone having, for example, only a day or two left to make their response? And again, that's pretty iffy on the question, so I apologize for that, but it popped into my head.
I guess I'm not sure I'm the best one to answer that, but to respond, I would say that the chief does have her order can stay up to effect 150 days after the disaster. So you're going to know when the pause button potentially goes away. I mean, shouldn't be a surprise that our order goes away tomorrow and you only have 1 day or 2 days. But I certainly understand your concern, and it may be something we want to clarify with the court as we move forward with this.
I'll do some additional looking at it after today. Thank you, Mr. Chair.
Any other discussion or thoughts on the amendment? Not, I will close and move my amendment. All in favor say aye.
Aye.
All opposed say no. Motion carries. Are there any other amendments? I did have one other, which I'm not going to offer because I think there's enough things up in the air that this is something we should come back to. But when Sean was here, I asked the question, why do we have a sunset? Why is this power going away? Because my concern is when the next disaster strikes in October and we're not here to put something like this into effect, what happens? So I don't like the sunset, but I think we probably need to let the KEMA bill and the speedy trial bill and those things happen and then come back to this at some point in the future. So I'm not going to offer that amendment, even though I wish it would become permanent. So any other amendments? Do not see any. What's the pleasure of the committee on this one? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2227 favorably as amended.
There's a second. Representative Schreiber. Discussion? Not see any. Representative Hoheisel, you may close.
I close.
Heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes wanting to be recorded: Owens, Hoheisel, Heiberger. I can't see everybody on my screen, but I'm assuming it's Carmichael and O'Habasam. And Representative Neely. If I missed anybody, holler. Do not hear anyone. Let's move on to 2369.
Sorry, I forgot I was sharing my screen there for a minute. Okay. House Bill 2369 extends the Kansas Closed Case Task Force and provides for staff assistance from the Office of Revisor of Statutes, the Legislative Research Department, and Legislative Administrative Services.
Representative Carmichael?
Unless there are pending amendments, I would move that we report HB 2369 favorably for passage.
So let me tell you one that I have.
Never mind, thank you.
So, and this is one that came from the KBI. As you know, the bill provides that sets forth who the members of the task force are. And the 8th person is the CODIS administrator. And since this bill went into effect, the CODIS administrator, they've changed things up a little bit. And that individual now supervises more than they did before, and is potentially not the person that we want on this task force anymore. So they suggested some language that would say the CODIS administrator or other designee of the KBI Forensic Science Laboratory, the director of the KBI Forensic Science Laboratory. So we're just simply adding or other designee of.
Mr. Chair, did you want me to distribute that?
Oh, that's a good idea. Yeah.
Okay.
Please do. I don't know. I mean, it's not a huge deal. This is one I would hope we could have stuck on the consent calendar because I don't see it being controversial, but I certainly understand their request. So it's coming at you. You see it all right there on the screen. It's being emailed out, but again, it simply adds or other designee of. I will make the motion. Is there a second? Representative Hoheisel. It's on its way to you, but any discussion while we're waiting? Representative Carmichael, is your hand still up?
It is, Mr. Chairman. I apologize. You did call that needed change to my attention and I had overlooked it. I do hope I'm recognized though in a few moments because I want to see this bill become law.
Got it. Everyone receive the amendment? Oh, and you'll see Natalie is showing you on the screen I guess there was, it doesn't change anything else, but on page 3, she did have to say, because before we said the task force shall continue as it was in effect January 29th, or December 29th, 2020, and she added in as except as provided for in subsection A8, which is where we're making that change. Good? No further discussion? I will close and move my amendment. All in favor say aye. All opposed say no. Motion carries. Any further amendments? Don't see any, so back to Representative Carmichael.
Thank you, Mr. Chairman. Now, I would like to request and move that we report the Fred Patton relief bill favorably for passage. It is HB 2369 as amended.
Is there a second? Representative Hoheisel. Discussion. Do not see any. Representative Carmichael, you may close.
I close on this excellent legislation and move the bill.
You've heard the motion. All in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes. Owens, I think. Yes, Owens, Hoheisel, Heiberger, O'Hobson, and Carmichael. Now let's go to 2228. Natalie.
Thank you, Mr. Chairman. House Bill 2228 requires law enforcement agencies to adopt a policy regarding the submission of sexual assault evidence kits and allows those evidence kit collections at child advocacy centers or other facilities.
Any questions for Natalie? Okay, I will start off. I have 2 amendments. If Natalie, you want to get those 2 sent out. The first one has to do with the lab name of the Johnson County, or the Johnson County lab. It was raised in testimony that we didn't have the name the way Johnson County wanted it, and so this will fix that. Instead of calling it the Johnson County Criminalistics Laboratory, it'll be the Johnson County Sheriff's Office Criminalistics Laboratory. So simply a name change made in 2 spots. We'll wait on that to get sent out. In the meantime, I will move that amendment, seconded by Hoheisel. Let me know, shake your head when you get it. Or I've had a chance to read it. I'll watch for nodding heads and a glare from Representative Jennings' area. Okay, you should have them. And the one we're on is the one that says lab name. Everyone had a chance to see it? Any questions? Not, I will close, move my amendment. All in favor say aye. All opposed say no. Amendment is adopted. So now pull up the second one, which is also attached there too, or attached to the amendment, or to the email that Kathy sent out. This one was requested by the KBI during their testimony. After they had introduced the bill, there was some concern raised by a child advocacy center that wasn't, my understanding was it wasn't licensed, but it was operated by a physician or a physician assistant or a registered nurse, which was their intent all along. They were just concerned that for some reason, a child advocacy center may not qualify if we didn't add that in. So that's why those 10 words or so are being added in to make sure, to clarify that those types of centers would fit. I will move that. Second by Representative Jennings. Any discussion or questions? Representative Wheeler.
Really haven't had a chance to fully read this, but not specifically with Well, on line 32 of page 1, I guess it is. Be a child advocacy center recognized by the National Children's Alliance. Put in a position to introduce this kit in court. That's very problematic as to the number of witnesses that will have to be called to establish that this is a properly recognized center. I'm not going to oppose this bill. I'm just mentioning it's something that we have to be careful when we draft them.
Any other discussion on the amendment? Seeing none, all in favor say aye. All opposed say no. The amendment is adopted. Any further amendments on 2228? Not seeing any. What's the pleasure of the committee on this one? Representative Hoheisel.
Thank you, Mr. Chair. I move that we pass out HB 2228 favorably as amended.
Second. Representative Schreiber. Discussion. Representative Carmichael.
Thank you, Mr. Chairman. I hope everyone will have an opportunity to read the correspondence that the director of the KBI, Kirk Thompson, sent us following the hearing, as well as the correspondence that we received from, I believe it was the Sheriff's Association and the Chiefs Association. You know, I was too zealous, obviously, in my questioning of some conferees and on this bill, and I do apologize for that. However, there was some substantial disagreement between people in Kansas law enforcement as to whether or not this bill was actually necessary. The reason that these kits were not being processed and were not being submitted was not because Kansas law enforcement was derelict in their duty. The reason was because the Kansas legislature and former governors did not sufficiently fund law enforcement, and specifically the KBI and its laboratory, to be able to process these kits in a timely manner. In fact, the storage conditions were so bad that water was literally leaking through the roof. And so local law enforcement was told, either formally or informally, don't send the kits in unless you have a suspect. Now, with the additional funding that the legislature has provided, along with grant money and the new forensic science center that we have at Washburn, we have caught up. We have still, I think the evidence was, or testimony was, a couple thousand kits, but they're going to be taken care of in due course. And so it's our fault, not law enforcement's fault, that these kits weren't being processed. Then the question comes to, why do we need to put it in the law? First, to tell us so that we make a commitment that we'll make sure that we provide the funding necessary to catch rapists, child molesters. And second, because of the intimate personal indignity that victims of these crimes go through in order to gather this evidence. Late 60s, early 1970s, there was a terrible murder committed about 3 blocks from some of my best friend's house. It's called the Otero murders, and I'm not going to breathe the name of the culprit that did it. But because of good police work, the evidence was preserved even before we knew about DNA. And thereafter, there were hundreds of law enforcement officers and other people in Wichita who were eventually swabbed and excluded as subjects in that crime. And eventually, the final nail in the case was obtained through DNA evidence from specimens that were obtained before we even knew how to categorize DNA. And so why do we need a law? We need a law to let the victims know that when they go through the process of providing this evidence, it will not go for naught, that it will be processed, that the results will be put in the national database, and most importantly, people who commit these crimes will never rest, because even if we can't match it immediately, someday, as in the case of the scumbag who resides in Lansing State Penitentiary, someday we're going to catch you, and you will never rest. You will look over your shoulder for the rest of your life. That's why we need this law. Thank you, Mr. Chair.
Representative Humphreys.
Thank you, Mr. Chairman. I just would like to ask the committee if y'all remember, if they answered this question, that have there been cases that have been solved because of this, the great amount of test kits that we now have gone through in the last few years? I'm just curious, do we know any results or what, have we seen anything? Do y'all remember?
I don't recall that from the testimony. I know talking with Katie Wisman, who did not testify, but has been very active in this in the past. My belief is yes, but I don't have data or information to share with you. Representative Wheeler, maybe?
There have been, I can't specify all of them. DNA is fairly recent and has greatly improved. But I can tell you that there was one case that remained uncharged because we could not tie the husband to the death of his wife. Couldn't prove that she was dead until somebody found a mandible bone under the bridge at Pierceville, Kansas, that DNA established that it was the wife. And the case that we had charged against the husband was dismissed at preliminary hearing about a week before finding that bone. So he's free, and he's in a country to which we have no extradition treaty in South America. DNA is a very important thing in criminal law right now.
Yeah, I'm not saying it's not. I would be good to know, how what we've done has actually resulted in some, yeah.
We'll work on getting,
okay.
Maybe Ed might have something to add, and come on up, Ed.
Be good to, it's interesting to know. Thank you.
Thank you, Mr. Chairman. Ed Klump with the Kansas Association of Chiefs of Police, Kansas Sheriff's Association, Kansas Peace Officers Association. I was a member of that task force that put together that program to bring those tests forward. The number of tests that was presented in testimony, I forget the number of those tests now, that resulted in an identification through the system. The vast majority of those were people already known to the investigators and already known to be the perpetrator. I think the number was somewhere around 10 to 12. I'm not absolutely sure on the concrete number, but it was in that range of unknown suspects that were identified. And the information we got back on at least some of those cases were they were not prosecuted for other reasons. So I think there were some unknown suspects that were identified. I don't know if any of those were ultimately prosecuted because of that identification or not. That what you're looking for?
That's helpful. Thank you.
And what Representative Wheeler talked about, we have lots of cases that have been solved through DNA. I don't know if that was a rape kit type case, but certainly this has been a wonderful, and part of the backlog problem happened because it was so successful. We overloaded the labs with serious cases that we needed DNA testing on. They just couldn't handle all of them. So, thank you.
Any further discussion? Let's see, Representative Hoheisel?
I'll close.
Heard the motion, all in favor say aye. All opposed say no. Motion carries. The affirmative votes being recorded: Owens, Hoheisel, Heiberger, Carmichael. Where's Casey at? I'm sure he's a yes. We're going to put him down as a yes. There we go, Representative O'Havison. Hiding from us. Okay, let's do 2292.
Thank you, Mr. Chairman. House Bill 2292 creates exemptions in the Open Records Act for cybersecurity assessments, cybersecurity plans, and cybersecurity vulnerabilities. And I can take any questions.
Any questions for Natalie? Are there any amendments? Seeing none. Representative Hoheisel,
Thank you, Mr. Chair. I move we pass out HB 2292 favorably.
is there a second?
On, and stick it on the consent calendar.
Okay. Is there a second? Representative Owens. So we have a motion to pass it out favorably on the consent calendar. Any discussion? Seeing none. Representative Hoheisel?
Close.
Heard the motion. All in favor say aye. All opposed say no. Motion carries. The affirmative votes. Owens, Hoheisel, Heiberger, Ohabison, Carmichael. And just to make the majority leader and his staff upset with me, let's do another one. We'll just keep adding to the list. I mean, this is fun, right? 2363.
Thank you, Mr. Chairman. House Bill 2363 authorizes the appointed counsel rate paid by the Board of Indigent Defense Services to be higher than $80 per hour. And I can take any questions.
Questions for Natalie? Are there any amendments? Let's see, pleasure of the committee on this one. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out HB 2363 favorably.
Is there a second? Second by Representative Schreiber. Discussion? Representative Humphreys.
Thank you, Mr. Chairman. I should have acted on this sooner, but I find that open-endedness of it just can be anything over $80 troublesome for me. And I would like to have had some sort of guidance on what it actually could go up to. I think 80 is too low. I understand that, but I just think that open-endedness is a little bit too much for me, and I'll have to vote no. Thank you.
Any other discussion? Not seeing any. Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The affirmative votes being recorded. Representative Owens, Hoheisel, Heiberger, Carmichael, Ohabison. That is it for today, committee. I know we could have gotten more. And I talked to the vice chair beforehand, and we didn't think we'd get through half that. Too bad we don't have betting in Kansas on legislative committee hearings, because I could have won some money. Okay, I'm going to rattle off a list for the coming days. I don't know for sure when or how we'll get to them, but here we go. 2011, 2377, 2387, 2126, 2153, 2264, 2362. And then these are probably unlikely, but possibly 2365 and 2389. Those we just heard. So we'll see where we get. If we don't get to them, maybe we can see if they get blessed to give us a little bit more time. And I'll give you this list every day as we move through it. Representative Hoheisel.
I do have one question, just to clarify and for the benefit of the committee as well. Are you planning on doing final action Friday, so we need to be in the building?
If we're here on Friday, I'm guessing we will have final action on Friday.
Okay.
Put it that way. So kind of going over the week again, just reminding you all what I said yesterday. Tomorrow, we will open the hearing on 2416, which is the KEMA bill that got introduced and assigned to us today. Tomorrow will just be Natalie explaining the bill and us having the opportunity to ask Natalie questions. And I'm doing that because I want people to have plenty of time, or as much time as we can allow, for them to submit testimony, and I didn't think it was right for the bill to drop this morning, not be assigned to us until this afternoon, and people have to have testimony in by the close of business today. And the other good thing is I think we do have the chance to hear from Natalie, explain it to us all, we can understand what's in it, and that gives people that might be proponents or opponents the chance to find out more themselves, and so they can address that in their testimony, which won't be due until the end of the day tomorrow. Then on Thursday, we will continue with that hearing, and we'll see where we go from there. No promises on what the end of Thursday looks like or Friday. We'll just see how the next couple of days take us. You all know we've got this March 31st deadline out there. Our House Judiciary Committee position was we had till June 1st. Well, that bill didn't make it, and we passed the Senate bill, and so we're under a little bit shorter timeline than I thought I'd hoped we would be, but we'll work within that. So this bill is a start. We'll see where it goes. The Senate, my understanding, is introduced one this afternoon. I've not had a chance to read it. We'll see what it says. And again, I've heard we may see some language from the governor's office, so there may be multiple KEMA bills out there, and we'll just work our way. See where we end up, but at this point in time, the next couple of days, we'll have some hearings. I hope tomorrow after Natalie's piece, unless we grill her for an hour and a half, that we'll have some time to answer or work on some of these bills. So that's where we're at. I appreciate everyone's hard work today. We will see you tomorrow and keep working hard. So have a good evening. Thanks, everybody.